I'm from TrueView Inspections. I'm the administrative coordinator here in the office, and you'll see me at multiple events as well. And we know and understand that you have a lot of options when it comes to referring a home inspection company to your home buyers. And I'm here to tell you a little bit of what makes TrueView different from all the other options. And we know and understand that the inspection process comes at a very critical time in your transaction, and you're getting to that closing table, which is why we perform the great inspections that we do, and we provide really great customer service. So number one, we deliver immediate report delivery. No more waiting for the next day. Time is of the essence more than ever, and you and your homebuyers will receive the report to your inbox before the inspector leaves the property. And we always like to joke around, you can hold them hostage on site until you receive that inspection report. And number two, they say a picture's worth 1,000 words. Well, imagine how many words a video is worth. And all our reports come with HD pictures and videos. And number three, we have a 200% satisfaction guarantee. So this means that for whatever reason you and your client are not satisfied within 24 hours of receiving their inspection report, we're not only going to refund their money, but we're going to go ahead and pay for a subsequent inspection up to the original value that they paid with us. We do have an internal team here that schedules the inspections for you and your buyers, but I also have an online schedule available to you on our website, which I'm going to go ahead and drop that in the chat, and our phone number as well. But the online scheduler is available to you 24/7. And there is always a code on there to save your buyers a little bit of money. When you go and open the online scheduler, the code is going to be always at the top. You can find it right there. And of course, I'll leave the phone number so you can give us a call. We'll be more than happy to help you out.
Awesome. Yeah, Katie, please put all of your contact information in the chat. We will also include it when we send out the recording and the PowerPoint of this presentation in class. So thank you so much for your time. And if you have any needs for any of your inspections, please remember TrueView. They are a fantastic sponsor for us, and they really do look out for the tech-minded realtor out there. So there's a lot of great services that they provide that you don't necessarily find elsewhere. So Katie, thank you for everything that you do for the community. And we look forward to seeing you at our more events in the future.
Yes, thank you so much, and have a great class.
Thank you. All right, Shahr, this is your time to go ahead and share your screen, and we'll get started. Thank you so much, everybody, for attending the Stay Legal with Shahr class.
Okay, great. Thanks, Kevin. And I see more people come into the waiting room. So Kevin, if you'll go ahead and admit people as they come in, and we will go ahead and start. I'll share my screen now. Okay, so let's go to slideshow. Play from start. There we go. All right, everyone. Thank you so much for joining me this afternoon. This is Stay Legal with Shahr. This is part two of a two-part series. We did part one in August, and this is really an overview of hot legal issues facing the real estate professional community. Just to get this out of the way, I did this at the last training as well, but here is our disclaimer. All of the information presented today is for informational and educational purposes only. This information does not and is not intended to constitute individual legal advice. Please consult with your own legal counsel on your specific issues, and this information provided today does not create an attorney-client relationship with the presenter. Here are our topics. So part one, we covered a lot of important hot button issues, including fair housing, copyright, condo disclosure rules. And today in part two, we're going to go over ADA and website compliance, the FREC complaint procedure and how that differs with the association's compliance with the Code of Ethics, and submitting a complaint for either an ethics violation or the submittal of a complaint for an arbitrable matter and the difference between those. We're also going to go over presumption of a transaction brokerage and what that means in the state of Florida, E&O insurance, cybersecurity, and emotional support animals. So let's start with ADA and website accessibility. These claims are still on the rise. I am sure that many of you have heard that real estate agents and brokers continue to get sued by attorneys and their clients that have complaints over websites not being ADA compliant. The claims are on the rise, and courts are overwhelmingly applying the ADA to websites. So what are some of the steps that you can take to protect your business? Conduct an accessibility audit of your business's websites and the mobile applications. And then create a plan and execute on that plan to make your websites ADA accessible. Become familiar with the ADA accessibility standards that have been adopted in the Web Content Accessibility Guidelines, or hire an expert that is very familiar with these guidelines. Federal agencies have adopted the Web Content Accessibility Guidelines and standards in conforming their own websites. And oftentimes, these guidelines are cited by courts as sort of the standard for website accessibility. Include an accessibility policy and notice on your website. Consider purchasing software that can provide alt text. And when we talk about alt text, we're talking about if your website has photographs, which all of you are going to have photographs of properties on your websites and listings, and the alt text will simply describe what is in that photograph or describe what is in that video. And of course, the National Association of Realtors, the Florida Realtors, here at the Miami Association of Realtors, we know that brokerages have been receiving threatening letters claiming that your websites are not ADA compliant. And many times these law firms will indicate in the letter that they will file a lawsuit if you don't get your website into compliance. Many times they will also say that they are willing to settle the matter for a small fee. So we don't want you to be in a situation where a lawsuit is filed. So take inventory of your websites. Even though there is no clear law yet that mandates web accessibility for private entities, these lawsuits are being filed, and the attorneys and their clients are in some cases successful at claiming that these websites need to be ADA accessible. Let's move on now to FREC. FREC is the Florida Real Estate Commission, and they monitor compliance with Florida statutes that deal with the real estate professional industry, and they monitor compliance with what we call the Florida Administrative Code and those sections that govern the real estate professional industry. What are some of the things that FREC covers? Broker responsibilities regarding sales agents. For example, brokers may be disciplined for failing to direct, control, or manage their associates in conducting real estate activities. We recommend that all brokers have and maintain a policy and procedures manual which clearly outlines the brokerage practices and functions. Remember that sales associates may not collect any money in connection with any real estate brokerage transaction, whether as a commission, a deposit, a payment, a rental, or otherwise, except in the name of the broker employer and with the express consent of the broker employer. That is another area of the law that FREC would govern. Selling business enterprises. Brokers are authorized to sell a business opportunity or business enterprise. This applies to businesses that don't include real property or land. For example, a retail store. And the statute does describe, it has a definition of real property or real estate that includes any interest in business enterprises or business opportunities. FREC also governs sales associates that form professional corporations. So anytime we're dealing with a situation where a sales associate and broker associate are creating a professional association That's known as a PA, which is really just a corporation, a professional corporation, or a professional limited liability company, which is your other option for your business entity. It has to be done in their licensed name only. So the governing of creating these entities, the sale of business enterprises, as I mentioned on the previous slide, broker responsibilities regarding their sales agents, all of these are governed by FREC, and they're listed either in Florida statutes or the Florida Administrative Code. If you have any issues with these topics, that would not be something that you would report to the local board or to the Miami Association of Realtor board. You would contact and report directly to FREC. Now, how does the FREC complaint procedure work? You have to file a written complaint with DBPR, and DBPR will then take that complaint and they will review it. They will determine whether or not the allegations in the complaint, if they're taken as true, so they read the complaint and they say, okay, if I read this and I take all of these facts as being true, is there a violation of these particular sections of the Florida statute? And there's two statute sections that govern real estate professionals, Section 475 and Section 455. So when you're dealing with a violation of Florida law that comes under those two statutory sections, that is when you would file a complaint with FREC. Then the DBPR, if they take the facts as true and think that there's a violation of those statutory sections, they will begin to investigate the matter. They will notify the licensee or their attorney by providing a copy of the complaint or any other documents that prompted the decision to investigate. If the complaint is against a sales associate, notification is not provided to the associate's broker until 10 days after the finding of probable cause by the probable cause panel or DBPR, or until the sales associate waives their privilege of confidentiality. Please note that these complaints are confidential. They are not to be shared with anyone except your own counsel if you have retained counsel. So when you file the complaint, do not share the filing with any other individual or entity unless it is your own attorney. There are time limitations. Buyers or sellers can file an administrative complaint within 5 years of the incident occurring, or the incident is discovered or should have been discovered. So that's a 5-year statute of limitations on the filing of complaints with DBPR. FREC is directly responsible for addressing complaints against licensed brokers, salespeople, real estate firms, and real estate educators. Now, what can FREC do and what can FREC not do? FREC can suspend a license, revoke a license, refuse to renew a license, or impose a $5,000 fine for each count or separate offense. So again, if you have a complaint and it alleges a violation of either a provision of the Florida Administrative Code or Florida law, that would be filed with FREC through DBPR as opposed to the local association. Now, the local association, so for example, your local Miami board, we make determinations, our hearing panels make determinations on whether or not the National Association of Realtors Code of Ethics have been violated, not whether the law has been violated, not whether the regulations in the Florida Administrative Code have been violated. It's only based on whether or not there has been a violation of the National Association of Realtors, which Miami has adopted, the National Association of Realtors Code of Ethics. remember that our boards, so the Miami board, your local association board, cannot require realtors to pay money to parties filing ethics complaints. So when you file an ethics complaint alleging a violation of a provision of the Code of Ethics, the remedy will never be one party has to pay the other. The complainant has to pay the respondent, or the respondent has to pay the complainant. We also cannot award punitive damages for violations of the Code of Ethics. We also cannot suspend or revoke anyone's license. So it's important to note that the emphasis of filing the ethics complaint is really educational in nature. So if we find there has been a violation of a provision of the Code of Ethics, generally what will be done is the following, and it's a range, and it depends on the severity of the violation. Courses may be mandated that the panel feels that the violator needs to take, certain continued educational courses, refresher courses. Fines can also be instituted, but those are fines that are paid to the association, and those fines can go up to $15,000 per violation. Generally, that is a severe remedy, and generally that would not be done unless there have been repeat violations or something extremely severe in nature. Now, please note that you may have a violation of Florida law, and thus you want to file something with FREC, and that same incident might violate Florida law and violate a provision of the Code of Ethics. So we often have cases where a complainant is filing a complaint with the local board for a violation of the Code of Ethics, and then they also file a complaint with FREC through DBPR, and that is allowable, and the local board is entitled to decide whether or not they want to move forward with the ethics complaint while the FREC complaint is pending. So they can be filed simultaneously. It would just be for violations of different things. One for a violation of a provision of the Code of Ethics, one for a violation of state law or the administrative code. Now, boards and associations, one of the really valuable things that you gain from being a member of Miami or a member of any local board that is an NAR affiliate is that realtors, if they have a contractual dispute between each other, where they're arguing over monies that should have been paid, generally they are commission disputes. Those can also be filed with the local board. And the local board grievance committee will get the complaint, and they will decide if the issue is what we call an arbitrable matter, meaning that it is a contractual dispute or a non-contractual dispute in accordance with section 17-4 of the Code of Ethics Manual. Now, you all can get a copy of the Code of Ethics Manual. If you just Google National Association of Realtor Code of Ethics and Arbitration Manual, the 2021 version will pop up. They have it in Word and PDF versions online. Miami has adopted that Code of Ethics Manual. So if you go to section 17-4, it explains what an arbitrable matter may be. Generally, it's surrounding procuring cause disputes, compensation disputes. So those would be arbitrable matters. You, as a member of the Miami Association, have submitted yourself as a member to mandatory mediation first for those matters, and then arbitration. The reason why we provide this service is so that you are not spending a costly amount of money on court fees and legal proceedings when you can arbitrate the matter and resolve the matter with the local board. So I encourage all of you to take a look at the Code of Ethics manual, become familiar with the Code of Ethics that you all should be abiding by and familiar with and adhere to, and also what may be considered an arbitrable matter under 17-4. Presumption of transaction brokerage in Florida. So here in Florida, we have what's called the presumption of a transaction brokerage. What does that mean? A real estate licensee cannot operate in the state of Florida as a dual agent. That means that they cannot represent as a fiduciary both the prospective buyer and the prospective seller. It used to be that Florida allowed dual agency. Florida does not allow dual agency anymore. So you cannot represent in a fiduciary manner both a buyer and a seller. Remember that when we say fiduciary, what we're saying is that if you are operating in a fiduciary matter, that requires being bound both legally and ethically to act in the other's best interest. And the reason why they outlawed this is because they realized that there was no way that you could be acting in a buyer and seller's best interest by being a fiduciary on both sides of the transaction. Now, what we do allow and what you all are considered as operating under from the get-go is a transaction broker. So we have under Florida law this presumption that unless the licensee has established in writing with the customer or client that they are a single agent, they are representing that customer as a single agent, meaning as a fiduciary, or you can specify in writing that you have no brokerage relationship, then the presumption is that you are a transaction broker. So what is a transaction broker? It's a broker that is providing limited rep to a buyer, a seller, or both in a real estate transaction, but you are not representing either in a fiduciary capacity, and you are not acting as a single agent. If you're acting as a single agent, it means you're only representing one side, and you're doing so in a fiduciary capacity. There are standard Florida Association of Realtor listing agreements. There's one for transaction listing agent, transaction broker listing agent, which is the standard one. There's a single agency one. And then you can also, during the deal, if the seller authorizes it or asks for it, you can switch from being a transaction broker to a single agent or a single agent to a transaction broker. But it is only upon the seller's authority and consent. So here are some of the differences between a transaction broker and single agency. Transaction brokers, what do you have to do? Deal honestly and fairly. Account for all funds received from the buyer or the seller. Use skill, care, and diligence throughout the transaction. Disclose all known facts not readily observable to the buyer that would materially affect the property's value. Present all offers and counteroffers in a timely manner, unless otherwise directed by the licensee in writing. And there is a limited confidentiality as a transaction broker. So what does limited confidentiality mean? It prevents disclosure that the seller will accept a price less than the asking or listed price. It prevents disclosure that the buyer will pay a price greater than the price submitted in a written offer. It prevents disclosure that the motivation of any party for selling or buying. It prevents disclosure that a seller or buyer will agree to financing terms other than those offered, or any other information requested by a party to remain confidential, and any additional duties that are mutually agreed to with a party. Here are the responsibilities of a single agent. They are representing only one party to the transaction. They have to deal honestly and fairly, just like a transaction broker. They have to account for all funds received, just like a transaction broker. They must still use skill, care, and diligence, just like a transaction broker. They must still disclose all known facts. They have to present all offers and counter offers in a timely manner. So this is all the same as what a transaction broker has to do. Here's a difference. Loyalty to the principal. That's the buyer or the seller, whoever you're representing. Obedience to the principal, and duty to disclose everything the licensee knows about the transaction and the other party to their principal. Meaning, if you are a single agent, you have to disclose everything that you know about the transaction and about the other party to your client, to the person that you are solely representing. That is different from that of a transaction broker. A transaction broker, as you can see in the last point, has what we call limited confidentiality. So if there's any information requested by a party to remain confidential, a transaction broker must do that. As opposed to a single agent, if you're representing the seller and you get information that the buyer tells you about something, you must tell your client. You have an obligation to your client as a single agent to tell them. As opposed to a transaction broker, where if you're repping the seller and you're representing the buyer as a transaction broker, and the buyer says, I need to disclose something to you in confidence, that information must remain confidential. So that's the major difference. It's these last 3 points. As a single agent, you have loyalty to the principal, you have obedience to the principal, and you have a duty to disclose everything to your principal. All right, errors and omissions insurance. And I know I see a couple of hands up. We're going to wait until the end to take questions. It is only a 1 hour legal training today, so we need to try and just get through the material. So please, if you would, just hold your questions and we'll try to get through them at the end. Errors and omissions insurance, or E&O insurance, very important for the real estate professional community to have this insurance. What should you be looking out for in one of these policies? Many brokers and agents have expanded their suite of services over the last several years. And a lot of you have expanded your digital offerings to include some tech-driven services like virtual showings, virtual staging, as well as, you know, the writing of sight unseen offers. That's very common today. Other brokerages have expanded even above and beyond traditional services. So they're offering property management, commercial brokerage services, relocation services. Anytime your offerings change, you have to ensure that your entire portfolio of services is covered by your E&O policy to avoid any potential claim denials. So whatever it is you're doing, you have to make sure your policy covers what you are doing. Make sure your policy covers discrimination. Many E&O policies do not. It is specifically excluded. So you have to ask your insurance agent or insurance broker if the policy specifically covers discrimination. There have been a significant increase in discrimination claims over the past year. So please make sure that you check for this. Oftentimes they will provide this type of coverage, but you have to pay an additional premium. So the takeaway for protecting yourself in terms of E&O insurance, check for those policy exclusions. Real estate E&O policies often exclude claims related to earnest money errors, bodily injury, environmental issues, damages to lock boxes, but an endorsement may be available. And remember to always report both formal and potential claims to your carrier as soon as you become aware of them. If you wait to report a claim, depending what's in the policy, they may deny coverage. What's the other big threat to the real estate professional community? And it's so sad, and it happens every day and more every day, and it's cybercrime. The real estate professional community is being targeted for cyber crimes. The criminals have caught on that you all handle extremely sensitive personal information. You handle driver's licenses, you get social security numbers, you get paperwork that has full bank accounts and credit card numbers. You need to protect yourself from cybersecurity crimes, because you can be personally liable and your business can be liable for any damages that result to an individual from theft of their personal information from your business, from something that you have received. So you need to do a couple of things. First, if you are going to request this type of sensitive information, really make sure if you need it. Don't ask for anything that you really don't need. And if you need some of the information and not all of the information, ask your client or customer to black out any personal information that you don't require. Consider creating a secure web portal to receive this information. Receiving paper information and then having it spread all over your office in an open location really opens yourself up to risk on all sorts of levels. You know, and I know that some say, well, I get the information and then I shred it. That's great, and that should be included in your policy. But the submittal of that information, if you're getting it through a text message, for example, or you're getting it online through an email and it's not a secure password protected portal, really opening yourself up to liability here. There's actually a federal law that also makes it illegal depending on how you handle the personal information. It's called the Fair and Accurate Credit Transactions Act, and it was adopted in 2003. And it details the proper and legally required procedure for disposing of data records. So I want you all to be safe and protected. And so it's very important to secure and back up your data. It's also very important to take a look at cyber liability insurance and make sure that your company has data protection protocols, because that will help you fight a claim if there is any loss or if there is private information that's been stolen. Once you get that cyber coverage, or you're in the process of investigating cyber coverage, understand the limits of that coverage. So just because you're getting cyber coverage doesn't mean it covers everything. You really have to read the policy. And this is really a scary statistic. Ransomware attacks are up 486% just from 2018 through 2020. And real estate fraud is a top 10 internet crime. There was around 213 million stolen in 2020 alone. So it's really vital that you seek insurance coverage for third-party losses as well. Client loses money as a result of a wire fraud scam. Those are rampant today. Make sure your policy covers that. Any kind of extortion expenses in the event that you're a victim of ransomware. Expenses that you have to pay out for the loss of personal information. You know, when you receive, if unfortunately, you know, our data has been at risk for many years, and I oftentimes will get those letters from big box retailers saying, you know, we're sorry, but all of your information has been stolen, and we had a data breach, and you're in that data breach. That's a lot of money that they have to pay out to send those letters. And then they usually offer you some sort of protection where you can sign up with a provider to check your credit. And you would have to do that as well if you were the victim of this. So the insurance policy is created to pay for those expenses. So make sure your insurance policy covers that. And this is the National Association of Realtors. They've put out 5 steps to achieve data security. Take inventory of who has the sensitive information in your company, who has access to it. Is it really necessary to collect all of that information? Develop a protocol for securing that information, and then develop a protocol for getting rid of the information. They call it lock it and then pitch it. So lock down the information, get rid of what you don't need, get rid of it in a way that complies with the federal law. And then plan ahead and develop some post-breach procedures. Okay, our last topic of today. I get so many questions about this, and I was going to bring my emotional support monkey with me today, but I don't have him with me. We've all heard of emotional support chickens and tarantulas and baby pythons and you name it, we've heard about it. They want to move in. They want to bring their emotional support animal with them. What do you do? What do you do if a client or customer of yours wants to bring one of these animals? What do you do if your client or customer is a landlord and they say, no pets. We have a no pet policy here. Well, first of all, saying no pets is perfectly legal. You can say that you don't want pets in your building or in your community. What you cannot say is you don't want animals. So that would be a violation of both federal and state laws, because emotional support animals and service animals are both legal at the federal and state level. So if someone says no pets, that's one thing. If somebody says no animals, that would be a violation of the law. If they say no pets and your client or customer has an emotional support animal, you can still bring that emotional support animal. You just have to comply with Florida and federal law on the topic. So what are the basic requirements? There's a difference, first of all, between an emotional support animal and a service animal. So let's go and let's talk about the emotional support animal first. Basic requirements. Generally, if the disability is not readily observable, a medical healthcare provider needs to provide a letter in support of the applicant's request for a reasonable accommodation to maintain that emotional support animal in a no pet community. The letter needs to state that the applicant is disabled, that the disability affects a major life function, which one, and how the animal ameliorates the effect of the disability on the major life function. The law in Florida is codified under section 7760-27. This is what we define as an emotional support animal in Florida. An animal that does not require training to do work, perform tasks, provide assistance, or provide therapeutic emotional support by virtue of its presence, which alleviates one or more identified symptoms or effects of a person's disability. This is important. Why is this important? You do not have to have a trained animal to be your emotional support animal, which is why You don't have to have that big tarantula wear a red vest that says emotional support animal. It doesn't have to do tricks. It doesn't have to have had any kind of specialized training. You just need to provide that letter that says that that animal is providing some sort of emotional support which is alleviating one or more of these identified symptoms or effects of your disability. If the disability, as I said, is not readily apparent, you can request additional information that reasonably supports that tenant's need for that particular emotional support animal. And the supporting information can include the following. Information identifying the assistance or therapeutic support provided by that animal. Now, some people ask me, well, does the letter have to come from a doctor? No, the letter does not have to come from a doctor. It only has to come from a healthcare practitioner, which can include a telehealth provider, a nurse practitioner, a psychologist. The different definitions of what is a healthcare practitioner, it's defined in Florida statutes. Here's what you cannot require. Landlords cannot charge extra compensation for allowing the animal. So if you have an emotional support animal, they can't charge you a pet deposit or a fee. Housing providers in Florida also have to accept a valid request from a tenant to live with that animal. That is considered a tenant's request for a reasonable accommodation. Now, here's where it gets tricky. If the landlord believes that that emotional support animal poses a direct threat to the health or safety of others, or poses a direct threat of damage to property, then they can deny the request. But if the request can be reduced or eliminated by providing another reasonable accommodation to accept that animal, then they have to accept the animal. So it gets very tricky. And that's why in many cases, we're seeing individuals moving into no pet policy buildings or communities with these emotional support animals. Landlords also cannot request information that details the diagnosis or severity of the tenant's disability. So all they have to say is, I'm disabled, this is the problem, and this is why I need the animal. You can't then say, well, I want to see a proper diagnosis, or I want to know how bad it is, or please tell me, please give me a copy of your medical records, or you can't do any of that. There are penalties, however, for falsifying information. So let's say that somebody really does not need an emotional support animal, and they get a healthcare provider to make it up. Florida statutes does provide for this. Okay, so a person who falsifies the information for an emotional support animal commits a misdemeanor of the second degree. So it is a criminal offense. Within 6 months after conviction, a person must perform 30 hours of community service for an organization that serves persons with disabilities. And then Section 456 of the Florida statutes was amended to provide that any health professional who provides information indicating that a person has a disability and they don't, they are subject to disciplinary action. So there are penalties for falsifying information. That's really the only safeguard that we have in the Florida statutes. So now what's the difference between an emotional support animal and a service animal? There's a huge difference. A service animal is considered just to be a dog. First of all, it's a dog who is trained to perform certain functions. So Florida has a definition, and then at the federal level, the Americans with Disability Act has a definition. So Florida's service animal law applies to animals that are trained to work or perform tasks for someone with a physical, mental, psychiatric, sensory, or intellectual disability. And the work that the animal does has to be directly related to the person's disability. The ADA further defines the service animal just as a dog that is individually trained to perform tasks, to do work for the benefit of a person with a disability. And in some cases, miniature horses may also qualify as a service animal under the ADA. So I've also seen that, where you have a tenant who brings the miniature horse into the apartment. I happen to love miniature horses. I don't know that I could live with one in an apartment. I'd rather be on a farm somewhere, but I have seen it. So that's another little quirk in the federal law. So under the Florida and federal service animal law, they cannot deny you access to equal housing because you have a service dog. Absolutely not. And if someone has a service animal, then just like an emotional support animal, they have to be allowed to live in the facility. Now the bar is higher because service animals actually have to be trained. So you do have to have a disability related need for the animal, and the animal has to perform certain tasks for that individual. And if you go to the HUD website, if you just Google HUD guidance on service animals, there is a list of all of the rules and regulations on what qualifies as a service animal. And there's also information that the landlord can request, just like with the emotional support animals. They can request, if the disability is not readily visible, they can just request, do you have a disability and what is that disability? Yes, and I require this service animal, and the service animal is specially trained to meet my needs. Please note though that if it's not a service animal, it could be considered an emotional support animal. So it's a tricky area of the law. I'm seeing it more and more. I get questions all the time, what can the landlord ask for? What does the tenant have to provide? So hopefully this has given you some guidance. And if you're unclear on something, go to that section of the Florida statutes and take a look, or go to the HUD guidance on service animals. Okay, what are some things in the news? The federal eviction moratorium is over. I did a little panel discussion a couple of weeks ago that just talks about the history of the federal eviction moratorium, and it is no longer in effect. So just so that you all know, the federal eviction moratorium, when it was in place, it's not that it banned or outlawed all evictions or the filing of evictions. It just required that if an eviction were to be filed and the tenant could not pay the rent due to a COVID-related reason, like loss of a job or inability to work, something like that, the tenant had to fill out an affidavit that basically talked about why they were unable to work, why they couldn't pay the rent, why it was a COVID-related reason, that they made less than a certain amount of money every year. And that was like a defense to the eviction action. And then the eviction would be stayed, would be halted. So now that option is not available anymore. So the defense of using the the eviction moratorium and the paperwork that was required at the time to be filed no longer is in effect. The second big piece of news, and something that you all should be looking into and taking some classes on and reading the materials, the FAR as is residential contract has gone through many revisions. It goes into effect November 1st, the new as is residential FAR contract. Please visit the link that I have listed on this slide. Florida Realtors does a great job of going through in a tutorial style fashion every single change to the contract. Become familiar with the changes, understand the changes. This is the most widely used form that we have in Florida for real estate professionals. There have been many additional riders added as well. There's a new mold rider. There's a rider for the use of PACE financing. So changes to riders, additional riders added, as well as changes to the body of the as-is contract. So take a look at that link. You can get a copy of this slideshow. Kevin can send it out, or take a screenshot of this link so that you can familiarize yourself with all of those changes. And that concludes part 2 of our Keep It Legal presentation. If you need any more information, you can email me at the email address listed below. If you have follow-up questions that we can't get to in the next 5 or 6 minutes, you're welcome to email me. And thank you all so much for joining us today. I hope this information was beneficial to you and gives you something to think about. We're always concerned about protecting our members, protecting the real estate industry, and giving you some legal topics to think about and consider. Kevin?
Yes. Do we have any questions for Shahr? You can put them in the chat and I'll read them, or you can pop on the screen right now.
So I have, there's some in the chat right now. Let's see. Oh, whoops, my screen just went blank, my black there. Let's see.
Yeah, you can either go back one or just hit escape or
Okay,
end your share.
I'll just stop. There we go. I'll stop share. Okay. So in the chat, I've got, does this apply to tenants and landlords? Maxine, can you clarify, does what apply to tenants and landlords? Let's see, just go ahead. Oh, does the tenant agent have to disclose the emotional support animal, or can they say they don't have to disclose it? Well, here, my feeling on, disclosing or not disclosing is you don't necessarily have to disclose it in the initial application. I mean, they can't deny a valid emotional support animal. That's the law. So my true feeling on this, and I think the appropriate legal advice on this, is to always disclose it, and disclose it in the beginning. And if they say no, then you can fight that. Do you have to 100% disclose it? Well, you shouldn't be lying on an application. So if an application says, do you have any animals? Technically, you would need to say, yes, I have an emotional support animal. If the application says, do you have any pets? An emotional support animal is actually not considered a pet. So would you have to disclose that? Probably not. But the landlord will then eventually find out, and then you should be prepared. The tenant needs to be prepared to produce the documentation. Because if the disability is not readily observable, the landlord does have every right to ask for that letter from a healthcare provider about the need for the emotional support animal and the disability associated therewith. So that would be my answer to that question. How many emotional support animals can one tenant have? I think they can probably, there's no clear answer on that, but you can have emotional support animals, plural. As long as you have that letter from the healthcare provider for each emotional support animal and what they're there for, it's probably something that is allowable. Now, again, if you have a situation where the landlord's like, listen, this is impacting the health and the safety of the other tenants, and this is why, you may be able to fight it. But again, it really just depends on the facts of each individual situation. Okay, let's see what else we have here. When you become a transaction agent, do I need to revise paragraph 10 of the listing agreement? So nobody becomes a transaction agent in Florida. You are by default all considered transaction agents. There's a presumption of the transaction brokerage in Florida. If you're using the standard Florida Association of Realtor listing agreement, there's nothing you have to change because that's for your role as a transaction broker. If you want to be a single agent, you have to use the single agency listing agreement. So there's two separate forms for that. Let's see, I'm just going through the questions. Okay, that's everything we have in the chat. So Kevin, I think if anyone has any other questions, that's all we had in the chat for today. So I hope you guys have enjoyed this. And you're welcome. And like I said, if you have any questions, go ahead and email me. Thank you very much.
Thank you. And we'll have a recording of this session along with the PowerPoint sent to you in a few days. Shahr, thank you as always for being a tremendous resource for our members. And we thank you so much for your time.
Great. Take care, everyone.
Yeah, but on my way home, yeah.